Yeah, Mr. Rowe.
Thank you, my Lord. I was taking your Lordship through some of the material in the evidence with a view to inviting your Lordship to consider this suggestion that there was simply no case to answer. I think I got as far as talking about the security at the gated community, and I said I had a few more references in that connection. Can we go in volume 3 to page 558, please?
What are you trying to establish? That there was good security?
That there was good security, yes. I mean, maybe I'm over-egging the point and labouring the point in doing that, but it's the practical difficulty, of course, is the nature of the case. Whatever I say about it, there's always going to be some theory that someone can devise physically could have happened, but it's necessary to set it all out, albeit I'll do it as fast as I can, bearing in mind the implication, perhaps, of your Lordship's question.
The third man could have got in without someone noticing.
Yes, that's the gist of it. My Lord, volume 3, page 558. We're in the evidence of Mr. Powell, who's been recalled. This is because the court has gone on a site visit, and they've got some further evidence from some people in the light of that visit. At the bottom of 558, there's reference again to the checkpoint. And over the page at 559, line 11, were you aware of any reports of trespassers on the night of the 23rd, the morning of the 24th? No. There was none. Over the page at 560, there's some evidence here about the possibility of getting into the property from the beach. Because as your Lordship will have gathered, the setup is that the house is on Ocean Drive, and its front is on Ocean Drive, but its back is by the sea. In fact, as your Lordships also have gathered, no doubt there are two properties, a big one called the main house and a smaller one called the guest house, and at the relevant time, Mr. and Mrs. Vasyli were living in the guest house, pending the completion of the main house, which was more or less done, which in fact was what Mr. Pritchard and his wife were shown round during the afternoon of the 23rd. Anyhow, the bit of evidence I wanted to go to is here some cross-examination about accessibility from the beach. Starts at line 10. Would you agree with me that the Vasyli's property is accessible from the beach? It can be. That's challenged. It is accessible from the beach, says counsel at line 13. The riposte is, it depends what you mean by what you call accessible. Pressed again, line 19, it depends. I don't like my shoes wet. If the tide is high, it's not accessible. And then he goes on to say that you can use steps up from the beach. That's at 29. No one has ever tried, as far as he knows, to use the rocks. So it's not contended that there is as there couldn't be, a wall or a fence between the house and the beach. That would rather defeat the object of the exercise. But
But you're
access.
this is all material to be evaluated by the jury.
Yes.
It's not something that needs to be susceptible of copper-fastened truth at this stage.
No, not at all, my lord. No, precisely. This is just all part of the overall pattern of the evidence that the jury were entitled to, and indeed bound to, consider. The jury were clearly paying attention because they asked a question about this evidence, which we can pick up at page 563. The foreman at line 5 says this concerns non-residents, people who don't live here. If I'm coming there, not being a resident there, and I'm coming to visit, what is your procedure? The answer, when a non-resident comes to our gate, we have to get confirmation that they're coming to a resident, and once we sign, we get the license plate of the vehicle, their registration and all that stuff, and all their information, and who they're coming to see. Then we call the resident, and the resident must confirm that they're coming and they're allowed access. And we also give the time of them, from which one can infer, or one might infer, the Lordship's right, of course, I don't need to go beyond saying one might infer from that anybody who came to the property, unless he or she came clandestinely via the beach or by scaling a fence or something, would probably have come through the barrier, unless it was somebody who lived on the estate, of course. So that's the evidence about security. The other point perhaps to mention in this context is that the defendant, the appellant's own account in interview of what she had done was that she had walked at dusk, the 20 minutes or so from the guest house where she was residing to her daughter's house alone, which doesn't again suggest that it's an area where people are jumpy about the possibility of intruders. There's a bit of evidence about the house itself, which I wanted to show your Lordship very briefly. That's at page 608. This is in the evidence of Inspector Johnson. Line 16, he is asked, did you ever search the perimeter of that property, meaning the property where the deceased was killed? Yes. When was that, sir? The day I went there, on the 24th. That property is secured with a front wall and gate, wall on both sides. The area is a gated community, etc., etc. Reverting to the sequence that I adopt in our printed case, we make the point at para 24, the house contained many valuable items. That was I won't take your Lordship to it now, but that was something that was accepted by the appellant in her interview with the police. And again, I won't take your Lordship's and your Ladyship to it, but one of the police officers gave evidence at page 341 that one of the things that had been found in the upstairs bedroom, he'd noticed as part of his notes what was there was a gold Cartier watch. So it corroborates that there were indeed valuable things there. The point being, of course, that we know none of them, as far as we can tell, were taken. Over the page at 25, this is page 1690 if you're following it in the electronic version, I make reference to page 1690. Make reference to the deceased's alcohol abuse problem, sometimes abused prescription drugs and took cocaine. We take that from Mr. Pritchard's statement. That's referenced there. He had in the past been verbally and physically abusive towards the appellant. That's in the interview with the appellant. And indeed, on the 3rd of November 2013, we think it's that because she says 2 years ago, but mentions the date of the 3rd of November, she'd had to call the police because of that. And may I just invite the board to turn up those statements briefly. Those are volume 4. First of all, page 816.
Well, sorry, what's the point of this? Again, it's not a dispute that there were these statements. So what?
No, well, it's all
We know that
part of the pattern of evidence. Yeah.
Material, which
Well,
the jury have got to grapple with. But I guess
yes.
with respect, what's the point?
Well, because they are all points
there isn't
which...
any evidence that she was ever abusive, attacked him. Should be rather more in point.
Well, of course, my lord, I don't point you to any of that
Clearly
evidence.
It was an up and down marriage, and he got drunk and was abusive, and they had periods when they were not together. Well, so what?
Yeah. Well, my lord, some jurors might have thought that. Some jurors, putting that together with all of the other evidence, might have concluded that they could be sure, in the absence of any evidence from the defendant on the issue, that she was the one who had committed the crime. That's in a nutshell what we say about it.
Well, this is all directed to the no case to answer point.
Yes.
And you say that all of this evidence taken together combines to provide the setting for a possible finding by the jury that his wife had plenty of reason to be, how shall I put it, inimical towards him.
Yes. Well, that's essentially it.
He was killing him.
No, but it's all part of the evidence.
Well, I'm working my way through it, my lord, but I will take the hint about this part of the evidence and move on.
It's purely me.
Well, quite.
Could I say, Mr. Ray, that for my part, I think it's quite helpful to be taken to this material.
Yes. Okay. Right.
Very well, I shall
Bug away.
take that as the majority verdict on that issue. I'd plough on, if I may. So I'd gone to page. I'd ask your Lordship to go to page 816, just to make good what I was saying about the background and the statement of Mr. Pritchard. He says at 8116 this is volume 4, as I say, he'd known the defendant and the deceased for 22 years. There's the reference to the abuse of prescription drugs and cocaine about an inch or so down. And he says, towards the end of that statement, about 7 or 8 lines up, I have known, this is on page 817, I've known that during their relationship and because of the alcohol and medication abuse, Phil and Donna have been separated numerous times, but they've ended back together. Making good my point about the abuse, just to show you where that is, that's at page 842, which is the interview with the appellant. 842, question 27, about halfway down the page. My information is that Mr. Vasyli was verbally and physically abusive to you. What do you say to that? Yes, in the past. My information is that Mr. Vasyli was so abusive to you recently that so much that you called the police on him here in the Bahamas and as well in the United States. What do you say to that? I called the police on him on the 3rd of November 2 years ago in the US, not the Bahamas. Over the page, how recent in the Bahamas was your husband verbally or physically abusive towards you here in the Bahamas? I would say 1 month ago. And it's out of sequence, but since we're looking at this particular bit of the evidence, I think my own friend said that nothing was asked about the fight. In fact, I'll come back to the fight later, but there is a question about that. It's put to her that she had said when confronted with the police shortly after these events that she had a fight. But anyway, I'll come back to that in due course. So that's the background. We then turn back to page 26 of our printed case to the 23rd of March 2015. We know that the evidence seems to show Mr. Vasyli fell down the stairs when drunk, cutting his back on the way on the glass in the picture frames. We take that from Nicolaza Gomez Quintana's statement. She was the housekeeper, and we reference that. It's 818, volume 4. All of these statements were read into the record. Mostly you can pick it up from the record as well. There's one exception, which is Mitchell Matthew, which for some reason we're just told it was read into the record, but you can pick some of that up from the judge's summing up. And we know then later on there was the visit by Jody and Miles Pritchard and Mitchell Matthew. My Lord, can I go back in that context to what was said by Mr. Pritchard about that? So back to 816. And if we pick it up about halfway down the page, on 22nd of March 2015, Donna sent out a text or email inviting my wife and me to visit their home in Old Fort Bay and to view their newly constructed home on the property. That's the main house. Jody and I accepted the invitation, agreed to meet them sometime after 3 p.m. at their home. On the 23rd of March, sometime after 3 p.m., Jody and I arrived at Phil and Donna's home, and we were greeted by Donna. Donna immediately told us that Phil was drunk and had fallen down the stairs and that he had started drinking since Friday. And then they describe how they go into the guest house and can see him there with paper towel with blood on it coming from the cuts to his back. Further on in that statement, top of page 817, he goes on to describe more about some of the conversations that they had at that stage. About an inch or so down, he says, Donna, Jody and I continued talking, and then Donna's nephew Mitchell, they called him Mitty, came in the patio where we were and joined in on the conversation, which was now about Phil and his drinking. I encouraged Donna to treat Phil with tough love, and she was talking about going to visit family members for a while. Donna then said that maybe she should go to Australia with her nephew Mitty, who was leaving the following day. And she said that she'd already picked out some clothing. And they discuss all of this for a while. And further down, we see that Mr. Pritchard and Mrs. Pritchard actually encouraged Donna to go to Australia with Mitty. That's about 2 inches up from the bottom. Jody and Donna came back out within 15 minutes, and we exchanged pleasantries and encouraged Donna to go to Australia with Mitty, i.e. the next day, it would appear, because that's when Mitty was leaving to go to Australia. When my wife and I left, Donna was fine and didn't appear angry or disturbed. It appeared as if it was a normal drunk day with Phil.
Yes.
Mr. Pritchard is, Mr. Matthew rather, was asked about, referred to this in his statement. This we have to pick up from the judge's summing up, volume 1, page 49. Line 11, question 10 of the interview. My information is that Mr. Vasyli, while you were there, appeared to be very drunk while the guests were there. Yes, my information is that while you were there, got into several arguments over his behaviour. Is that a fact? Not to my knowledge. And then he goes on to deal with other matters, which I'll come back to in chronological order later on. The appellant was asked about this in her interview with the police, and she deals with this at page 839.
Sorry, say that again, please.
So the appellant deals with this.
Which page?
839.
Thank you. Yes?
I should, in fairness, pick it up at 838, actually, just above. My information is that on Monday sometime in the afternoon you were at home with your husband along with friends when you and Mr. Vasyli got into an argument. What do you say to that? No argument. My information is that around the same time your friend and your husband was drunk and you and he were arguing about how he was embarrassing you. What do you say to that? He had been drinking, and I said, Philip, you need to pull your pants up because they're falling down. They were falling down. I was speaking to him more as a disobedient child other than arguing. My information is that after your friends left, you and Philip were at home alone. What do you say about that? Yes, correct. My information is that after your friends and family left, you were upset that Mr. Vasyli had embarrassed you and that you had another argument with him. What do you say about that? I was upset with him more than arguing with him. And then the conversation turns to other things. So that's the evidence about, such as it was, about what was going on during the course of the afternoon. We know then, this is paragraph 28 of our case, the Pritchards then leave. And I've already mentioned what Mr. Pritchard said about this being a normal drunk day for Phil. Mr. Matthew says in his statement that he leaves soon afterwards, leaving Mr. Vasyli and the appellant alone together, and goes off to the home of Lauren, Mr. and Mrs. Vasyli's daughter. A few minutes walk away, and we can pick that up going back to volume 1 and page 49. This is the judge, you'll recall, summing up to the jury, telling them about what's in the statement that was read into the record. Line 19. Mr. Mitchell says in his statement that he left not long after the Pritchards. I think it was about 15 minutes. They were all at the cottage. No one else was there when he left, meaning he left Donna and Philip there. He went to Lauren's house. What he said later was that he saw the accused upstairs when he went to bed, when he went up to pack around 9 or 10 after 9. My case gets it wrong when it says around 9 or 10 p.m. It's 9 or 10 minutes past 9. And the appellant herself had said in her interview that she had left around 7:30 to 7:40. The evidence next picks up the next morning when the gardener and handyman, Mr. Quintana, discovers Mr. Vasyli's body, and he's dead from a stab wound to the neck that had severed an artery. And we need to look in that context, if we may, at the pathologist's evidence about this, because we're told a bit more about exactly how this happened, all of which forms, one may think, part of the overall tapestry of it. And this is, can I ask your Lordship and your Ladyship to pick it up at 579, back in volume 3. Karen Sands, the pathologist. She starts on page 578 at line 18, if anyone needs to note that. But goes on to describe her findings. Line 20 on page 579, that Mr. Vasyli died from a stab wound to the neck. Where exactly was that wound located, Dr. Sands? It was on the left side of the neck, above the clavicle, so about here, indicating. And could you tell us how long or how deep was the wound? It was approximately 5 3/4 of an inch deep. And the direction of the wound, the direction of the stab wound was back to front, which means it had entered the skin behind where the end of the wound track end. The wound track was in front. The wound track was in front of where it entered the skin. So it's back to front. It's left to right and downward in his body. And she then indicates with a pen. We can't, of course, see what it was that she indicated with a pen, but if one can picture the length, the depth of the injury, 5 3/4 of an inch. Your Lordships and your Lordships have seen photographs of the
Yes.
of the knife. One can reasonably infer that it was essentially plunged in from behind, it would seem, in such a way that it was moving and straight down into the gap just behind the clavicle. That's what the evidence.
How does that help us?
It's all part of the pattern, my lord, as to what happens. I'll come on in a moment to precisely. But what I submit it tends to show is that he was stabbed from behind.
So what?
Somebody came up from behind. Well,
Don't know who. I mean, what we're trying to find out is whether there's a case to answer against this defendant.
yes,
There's no dispute about how he was killed.
no, I accept that, my lord. But it all forms part of the tapestry, which I submit ultimately comes to a position where one could properly come to the conclusion, not that one must, but one could properly come to the conclusion that the Crown's case was made out. I've described at para 31 the setup. I've said there through some patio doors. That's not perhaps quite right. There are three sets of three doors leading on to the patio. One of them comes from the kitchen. The other two don't. But what we do know from the statement of Mr. Quintana is that he had to open the patio door to the kitchen, in other words, the kitchen door. Having arrived at the house, found the blood on the patio, and your Lordship will have seen from the photographs there's blood all over the patio, but particularly a pool in one spot on the patio. He then has to open the locked door to go into the kitchen, where he finds the body of the deceased. We mentioned at 32 that the knife appears to come from a set of kitchen knives in a block in the kitchen. I won't pick that reference up unless you want me to, and we make the point at 33 there was a great deal of blood on the patio, blood on the outside and inside door handles of the patio door, i.e. the kitchen door, and blood in the kitchen. It was said by my learned friend in her submissions that we can see that what must have happened is that the earlier party had all been cleared away and a fresh gathering had taken place involving 3 people because there are 3 glasses. Well, my submission, that's reading rather a lot into that. One can see from the photographs what the state of affairs was when the scene was discovered the next day. But there's no basis, I submit, for saying that one can necessarily infer that, or even regard as probable that one party had broken up and another one had begun involving 3 people.
The evidence was there were 3 glasses on the table.
There are 3 glasses on the table. That's true. What we don't know, of course, is what permutation of I mean, there's I think I've mentioned in the case there's evidence generally that as to what they were drinking. That's Miles Pritchard's statement at page 817 that the women drank wine and the men drank beer. What we don't know is whether the men poured their beer into glasses or drank it straight from the bottle.
We don't know what was drunk from the blue glass, do we?
No.
Or whether anything was? Do we know whether anything was drunk from the blue glass?
I'm not sure we even know that. It might be apparent from the photographs whether there was anything in the blue glass. We've got a close-up of the blue glass, but it's so ornate
Well, I
that
don't
it's hard to
think
tell what's in it.
Trying to speculate.
No, I mean, quite.
I thought there might have been evidence about it. If it's clear that the men drank beer and the women drank wine, then it would be quite helpful to know what was drunk from the blue glass.
Well,
there we are.
I don't think the point was explored. My learned friend said that it had been accepted by the Crown. She said quite a lot of times in her submissions that we'd accepted various things, and I shouldn't be taken to be accepting that we did accept, or anyone, any of my predecessors as representative of the Crown did accept various things. But in that context, it's not, I submit, right to say that it was accepted by the investigating authorities that there had been 3 people. What was put was at least 3 people, because there were at least 3 people were there at some stage because there were 3 glasses. And I get that from volume 2, if I can just ask you, the board to turn that up, where this is discussed. Mislaid my copy. It's volume 2 at page 359.
Yes.
Indicates the presence, line 6, indicates the presence of other persons, or at least 3 persons there.
Sorry, you're reading line...
Sorry, my lord, line 6.
Thank you.
Yes, sir. So, going on through my chronological narrative, paragraph 34 of our case, none of the doors to the house showed any sign of having been damaged or tampered with, and nothing had been stolen. I should, in fairness, say that the witnesses were pressed on the question of the doors not having been tampered with, but I don't think it suggested that their evidence was about that was incredible, so for present purposes it doesn't perhaps matter very much. 352 is what I'm thinking of. We are here, I forgot to make a note of whose evidence this is, but we are here in the evidence, Mr. Ungrateful, of Mr. DC Stubbs, and at line 10 it said, "You're not trained as a locksmith, are you?" "No, sir, you cannot tell what locks were not working or what locks were not working. I could tell whether metal is tampered with." So that's what he says there, and there's some more evidence about that, just for, well, it's there already in my note at page 349. That's where it starts, actually, in Mr. Stubbs' evidence. Line 17, the door, they weren't tampered or tampered with, the doors weren't tampered with.
Well, your point is that there was evidence available to the jury that because of the lack of evidence of the doors having been tampered with, that this killing must have been carried out by someone who was within the house. I mean, that is a possible conclusion. That's your point, isn't it?
Yes. I mean, more generally than that, it's not consistent with the story that one often sees: somebody breaking in and then attacking the inhabitants of the property.
I think what's being put by Miss Montgomery is not an intruder, but somebody asked into the house, or
well,
state.
Yes, I mean, I'll perhaps come on, if I may, when I've dealt with all of the evidence I wanted to point to. But my anticipating it a bit, my overall point is really the one I started with. In order to make a case based on circumstantial evidence, which a jury could properly convict on, in the absence of any rebuttal evidence from the defendant, who of course is perfectly entitled not to put any rebuttal evidence in, any defence evidence in, it's not necessary, I submit, to adopt an approach which says you have to exclude as a matter of absolute physical possibility that anything could have happened. To some extent, the initially rather helpful analogy of the rat and the mouse, or the rat and or the cat and the mouse rather, or the cat and the rat, it may in some contexts be a bit beguiling, because that suggests that you are looking for a standard of absolute physical concrete certainty. This could not possibly have happened. That's not the jury's task, in my submission. The jury has to look at all of the evidence and consider whether competing hypotheses are ones that they can reasonably be satisfied they're sure are not, and don't represent the truth. And that's not quite the same exercise. My Lord, pressing on, if I may, we make the point, and this is perhaps another important point, at the bottom of 1691 in paragraph 34, Mr. Vasyli's body bore no defensive injuries, and the evidence about that we find in volume 3, at page 579, back in the evidence of Dr. Sands, the pathologist. So forgive me, that's where it starts. The evidence itself is at 583. We can pick it up at line 8. Dr. Sands, are you able to say whether that type of instrument would have caused that injury? I presume this is a knife, but the blade is covered in paper. I'll show you a photograph. And then it goes on, can you tell us what defensive injuries are? 15 defense-type injuries are usually injuries sustained when somebody dies from sharp force or stab wounds, and the distribution of the wounds are usually on the palms, on the back of the forearms, on extremities. If the person is lying down, for instance, they may put up in a leg or so. It is in order to protect vital structures. So if you have the opportunity to defend yourself, you would tend to see sharp force injuries, cutting wounds or stab wounds on the hands, on the back of arms and so on, to protect your face or any other vital structure. And in examining this body, Dr. Sands, did you find any evidence of defensive injuries? No, not in my opinion. No. And my Lord, my Lady, I do submit that's potentially quite an important point, because it puts a bit of it's a further piece of information that tells us about what the likelihood is as to the nature of the encounter. One can speculate about possibilities of other visitors coming, presumably on one of the ways it's put, coming peaceably, as it were, invited. One could see possibly, I suppose, maybe there had been somebody came and then a row developed. But what's curious about this is it appears to be there's the deceased, and in circumstances where he has no opportunity to defend himself, he is attacked, which I submit a reasonable juror could conclude that's evidence that tends to suggest it was the appellant who was the perpetrator of that, rather than it being, for example, a situation where somebody had come who was a visitor, but then the situation deteriorated into an argument. After all, we know it doesn't seem likely the visitor came armed, because if the visitor had come armed, the visitor would have used that weapon to commit the offence rather than going into the kitchen to get the kitchen knife.
Yes.
So it's all part of the overall pattern. Then we have the evidence, we mentioned this at para 35, of Constable Knowles seeing the appellant lying on the bed. Can I just ask your Lordship and Ladyship to turn this up in the record? This is volume 2, page 482.
Where did this take place, Mr. Rowe?
I'm sorry. This took place in the main house. Perhaps I should go back a bit further, actually, to page 481, line 19. This is P.C. Knowles describing arriving on the scene on the 24th of March. Earlier on the page, he's described seeing the deceased. Line 15, he says he asked Mr. Quinton de Graaf, what is the name of the person on the ground? He said it was Vasyli. After that, 19, I asked him if he resides alone. He told me no, he resides along with his wife, who is in the main house at the time. After he told you that, sir, what, if anything, did you do? Escorted me to the main house. What happened when you got there, sir? 28. I noticed a white female lying in the bed wrap up in sheet, crying and shaking. Okay, what happened after that, sir? I identified myself as Officer Knowles of the police K9 unit. Down a page, over the page. When the lady that was lying in the bed stated that her and her husband had a fight that night. Had a fight that night. What happened after she said that, sir? I cautioned her and arrested her reference to murder. He explains what he said when he gave the caution. And then he says at 14, what, if anything, happened after you cautioned and arrested her? Another lady came into the bedroom at the time when he was stating she had a fight with her husband. She gave her name as one Lauren Vasyli and stated the lady in the bed was her mother, one Donna Vasyli. Did anything happen after that, sir? Lauren whispered something to something to Mr. Vasyli's ears, and she stated nothing again. She whispered something to her mother's ear, and she said nothing else. So we submit that's a further part of the evidence which the jury were entitled to take into account. We mentioned next the question of the blood. I repeat my observation at the outset of these submissions about that aspect, and would respectfully wish the opportunity to respond, albeit briefly and punctually, briefly in writing about that aspect, if I may.
Yes.
My Lord, I'm grateful. But certainly, as I say, until my learned friend made her oral presentation to the board, her position was, as I've noted, to seek to explain why one might find blood on the dress rather than the appellant's, the deceased's blood rather than to say that there was no evidence that it was there at all.
I mean, the blood doesn't really prove anything, does it? Because, I mean, there was blood all over the place as a result of his earlier accident. And there's nothing to suggest that any blood that was on her dress was necessarily related to a stabbing incident. Which caused
On its own, my Lord, no. Again,
that doesn't prove anything, does it?
Well,
in circumstances where there hadn't been a previous accident, you'd say it was relevant, but circumstances where there's been an accident just that afternoon and there's all sorts of blood around, surely completely proves nothing.
Well, it affects the weight to be attached to the presence of blood. It may be that in light of the earlier bleeding of the deceased, very little weight can be attached to it. But I assume that your submission would be that it can't be dismissed entirely from the
yes.
Overall circumstances.
Yes.
Why not?
Because
It
being a criminal circumstantial case, all matters that are pertinent to the possibility of the circumstance that the injury was inflicted by the defendant are relevant and have to be taken into account.
Yes, I mean, my Lord,
you can't isolate individual items of evidence and say, well, because that proves nothing, it's thrown out of it.
Precisely. In most circumstantial evidence cases, one could take any one bit of evidence and say, well, that by itself doesn't prove the defendant guilty. But that's the point of circumstantial evidence. You look at all of it, and the fact that
the tradition analogy of a rope, all of these strands are bound together. Some are stronger, some are weaker than others. Some have very little strength at all. But when you consider the evidence in the round,
it's all part of this rich tapestry. Which
we can get into too many metaphors.
Perhaps the rope metaphor is the more traditional one. So I should revert to that really, rather than
we
try
can
to divide the
the
separate.
whole of the evidence, and
Yes.
each little bit we see, and we've read. I've read the summing up. I've read it all, but the question is whether you can meet the points that are being said against you about the specific weaknesses of the points relied.
Yes. Well, of course.
But if it's a simple question, well, there's a rich tapestry and she didn't give evidence, so it goes to the jury. Well, fine.
Yes. I mean, this is one of the 4 points that's subject to the specific attack, which is made in my learned friend's case and elaborated earlier today, and I'll deal sequentially, if I may, with that. But I do submit that, notwithstanding the fact that, of course, the other possible explanation for the blood makes it less strong evidence. You may say it makes it quite weak evidence. That's a matter of judgment. It nevertheless doesn't make it something that one should simply disregard.
It's also relevant what she said she was wearing that day.
I'm sorry, what it is?
It's also relevant what she said she was wearing. She never said she was wearing the multicoloured dress.
No. She said that she was wearing a Bahama handprint, which I think means a skirt and a T-shirt.
On another occasion, she said she was wearing the blue dress.
I think the blue dress, I think, was what she was wearing when she was encountered on the morning of the 24th. The one my learned friend describes as a night
she was
dress.
wearing that the previous day too.
Two different questions. One's about the evening blue dress. One's about when the Pritchards were there, Bahama.
Okay. But not multicoloured dress.
No. No.
Let's move on.
So anyway, our overall point, Your Lordships, I'm sure have well on board. We say all of that combined does amount to evidence, if unanswered, upon which a reasonable jury could feel sure that it was the appellant who had killed Mr. Vasyli. I should just qualify one thing in our printed case at 37, since I've got it under my eyes. We say at the end there it was possible to get access to the house by going around the entrance gate or from the sea. I think that probably wrongly separates out two things that are conflated. My friend will tell me if I'm wrong, I'm sure, but I don't think there was any specific evidence that one could simply circumvent the entrance gate. The point is that we'll see. I'll have to have a look at that. But in any event, we.
So are you saying that's right or it's wrong?
I thought. Well, I thought it was on reflection wrong because I understood that actually, if you read properly, the evidence about being able to get access to the house without going through the security people was evidence about being able to walk up from the beach. But no doubt my learned friend will point you to the passage that says I'm wrong about that in her reply, if I am. So I do submit that was enough for the jury to feel sure, if that case was unanswered, that it was the appellant who had killed Mr. Vasyli, and we make the point in our printed case about this. It places them together, supplies a motive for violence, strongly suggests that there had been an intruder, and of course there is the evidence about having said we had a fight, which, again, like all the bits of this rope, is capable of being explained away as being a mere metaphor, and it was a dreadful coincidence that when she says we had a fight, she was referring to a metaphorical fight, or to a fight which was short of what the Crown says happened, but it's part of the evidence in my submission which a jury was properly entitled to take into account, which could safely and can safely be left to the wisdom of the jury to work out, taken as part of the whole, what it leads them to conclude. My Lord, then, dealing specifically with if I may, with the attacks that are made by my learned friend, I'll start with the blue glass man point. I accept that the DNA analysis on the rim of the small blue glass shows that it's got on it the DNA of a man whose profile did not match the appellant or Mr. Matthew or Mr. Quintana, and that Mr. Pritchard's profile had not been obtained for whatever reason, so it wasn't possible to say definitively whether the DNA was his or that of some other unknown male. I do, however, make the point that there is no evidence about how or when the glass had last been cleaned, and I respectfully submit that this doesn't substantially undermine the respondent's case. This comes back to my point, I suppose, about not needing for a circumstantial case to exclude, as a matter of absolute scientific physical possibility, every competing hypothesis. Of course, the presence of the unknown DNA is taken by itself consistent with a different theory of the case, that there was somebody who got into the house, presumably unarmed, presumably without any force being used, and then unexpectedly set upon Mr. Vasyli. I say unexpectedly because there are no defensive injuries, using a kitchen knife that he'd grabbed from the block in the kitchen, and at some point that person had taken a drink from the glass, either because he'd had the drink and then decided to attack Mr. Vasyli, or perhaps he had a drink after having attacked Mr. Vasyli before departing. Who knows? I accept that as a matter of absolute, what's physically possible based on that evidence, then the evidence about the DNA is consistent with that. But that's not the question. The question is really whether that gives rise to a competing hypothesis, such that in the face of all of the other evidence, the jury were not entitled to reject that other hypothesis as not being a reasonable one. And in fact, I submit, really all that the presence of this DNA on the glass tells us is that either it's actually Mr. Pritchard's DNA, or it's that of some earlier visitor to the house whose DNA has not been removed by whatever cleaning process there might have been. There's no evidence about how the glass was cleaned, how it had been cleaned, who else had used it, or indeed transfer evidence. When my learned friend was addressing your lordship's and ladyship about the blood evidence, or lack of evidence as it's said to be, you were taken to the DNA primer about transfer. And the point was made there about how actually DNA lasts a long time and can be transferred on a number of occasions. It seems that when this submission is raised by the appellant, all of that is forgotten, and the presence of an unknown male's DNA on the glass tells you inevitably that an unknown male drank from this glass on the evening or the morning of the crime. Well, that can't, I respectfully submit, quite be right. And could I just take your lordship back to the DNA primer? This is in the second supplementary record or bundle of documents. It's at page, I think if you're using I think in the PDF it's page 34 if I've done the arithmetic right, but it's internal page 47 of the primer. Figure 11, illustration of possible A primary, B secondary and C tertiary DNA transfer. And you see the various drawings there. Blue figure to gun, primary transfer, blue figure to red figure to gun, secondary transfer, blue figure to mobile phone to red figure to gun, tertiary transfer. Apparently all of that on the appellant's case goes out of the window when it comes to the blue glass, which apparently is such compelling evidence that it must have been some unknown person who in fact was Mr. Vasyli's assailant who drunk out of the glass. So, my lord, that I respectfully submit does not, as I think one of the judges in the Court of Appeal put it, blow a hole in the Crown's case. Neither in that context, perhaps I'm repeating myself to some extent, but neither in that context can one, I say, infer from anything about the position of the glasses on the table and the fact that the bottles were in the bin, that what has happened is that the Pritchard and Mitchell party has ended, and this is actually a different scene where there are three people present. So, my lord, that deals, I hope, with that aspect of it. The timeline is the point about the pathologist, and as I understand what's said, and this is what's said in the printed case, and I think was said in my own friend's oral presentation as well, what is said is, well, you can tell from the fact that there was a photograph taken at 1:15 on the 24th of March showing rigor mortis present, that the deceased met his end at a time when the appellant definitely wasn't at the property. Well, my lord, I respectfully suggest that that is not what the evidence says. First of all, the pathologist herself did not say that. This is all, in fact, extrapolation by the appellant, who could have, but as she was perfectly entitled to, did not call any pathology expert evidence of her own. It's extrapolation by the appellant in those circumstances from the evidence that was given by the pathologist called by the Crown. And well, can we just go back to look at what actually was said about that? Because a specific question was asked. I think your lordships were showing this earlier, but I wouldn't mind if if it's all right with the Lordship, going back to it briefly. This is page 588 in volume 3. Line 18. In the meantime, you have not been able to determine the time of death, have you? I don't know the time of death. What was said, sorry, Lord.
Yes, go on.
What was said by my learned friend earlier was, I will look at the death certificate. That's another new point that's not mentioned in the case, but in our respect for submission, it was better left out of the case. In the face of that answer, it can't really, I say sensibly, be submitted that what the pathologist meant was, well, it was definitely after midnight. It was definitely on the 24th of March, not the 23rd, but I don't know exactly when on the 24th. You can't get that from that answer and from the fact that the death certificate says the 24th of March. The death certificate was adduced by the Crown, but there's no rule in my submission that every line of every bit of evidence that the Crown adduces by stipulation, to use the local term, is bound to be accepted as gospel truth by the jury. That can't possibly be right, in my respectful submission.
Just so Mr. Rowe can deal with it, I will be showing you section 19 of the Evidence Act, which says if it's admitted, it must be taken as evidence of the fact.
Taken as evidence, but that doesn't mean that the jury, as part of its overall consideration, it would be a very odd situation if that were right. What if the Crown adduces a statement which is broadly helpful, but in some respects says things which can't possibly be right as a matter of fact? Is the jury really meant to infer?
A distinction needs to be drawn between, on the one hand, accepting that this statement was made by this witness and that it contains the averments that it's seen to contain, and on the other hand, accepting as established beyond reasonable doubt every scintilla of the statement. I mean, it would be a remarkable thing if a statement introduced in evidence was taken to be proof beyond challenge of every single item that it contained. That would be a pretty radical departure from any criminal proceedings of which I have had experience.
Yes, well, it would be, and we'll hear what my learned friend has to say about the Evidence Act, but it can't, in my submission, it can't possibly be read to say that. And it follows from that also that my learned friend puts too much weight on the statement of the nephew, Mitchell, about the time at which he saw the appellant at the daughter's house. He says that he saw her about 9 to 10 past 9. It doesn't follow from that the jury had to accept that he was bang on correct about the exact time, and it cannot have been a minute past 10 past 9 that she was there. So, in my respectful submission, that this evidence just doesn't work. And the other reason it doesn't work for the purposes of seeking to blow the hole in the Crown's case. The other reason it doesn't work is because, read fairly, the evidence of the pathologist was not nearly so dogmatic about the way in which rigor mortis works as is now being suggested, and we can see that from page 581. I know your lordships were taken to this earlier, but I do respectfully seek to emphasise it. Line 13, you say it has an onset and a peak. Yes, most post-mortem changes have an onset time. Say 581, volume 3, have an onset time, an average time, and you have where you start to see the changes, and then rigor mortis has where you would actually lose the stiffening. As time goes on, the stiffening will actually disappear. Question, so what time period would you say is the onset? Answer, on average, it depends on factors. It depends on temperature, activity, but on average, it takes approximately 2 to 4 hours for rigor mortis to be noticeable, for you to appreciate rigor mortis, and then it peaks at about 12 hours. And again, that's just an average. And she goes on, what I mean by peak is that if you imagine a curve, it goes up, say 4 hours, you notice it, and in the next 12 hours, it speaks to the point where you can break what we call the rigor. But she emphasises, and she repeats the reference to average over the page at line 4, if after 12 hours on average you then break it, it will no longer return because it has already reached its peak. There was no evidence about what the factors were in the deceased's case.
Help me in relation to the point about 12 and 4 and 16. Talking about 12 hours after the onset.
My Lord, the evidence is not... I'm not sure I can help Your Lordship beyond. There's nothing else I can point to in the evidence that clears it up anymore. Really, we're left with the explanation that's given there.
Line 29 says the next 12 hours, doesn't it?
Yes, it does. In the next 12 hours, which, yes, I think that's where we've all taken it to be, that the evidence was that that's where the 14 to 16 hours comes from. In other words, which on the appellant's case, if you take that as an absolute rather than an average, and you take Mitty as having been absolutely spot on his timings, means that it can't have been the appellant. That's the point.
I think it was part of the appellant's case that the rigger had been broken in this case because the body was face downwards, and it was the arm we're talking about.
I'm not sure.
Was there any question asked about that? Is there any evidence, or is this an extrapolation from the evidence?
This is an extrapolation from the evidence.
Yes. What was meant by breaking?
Yes, I don't think. I mean, my friend will speak for herself, I suppose, in due course. But I don't think it said that the evidence shows the rigger had been broken. I think the point is that it was still there, even though the body had been turned over. So that you can tell that there was still rigor mortis present at that time, whereas it is said
would have been broken by the weight of the body, is what was being said, I think.
I suppose so, my lady.
If it had been breakable, it would have been broken by the weight of the body. I think that's what
yes,
the point was saying.
I suspect that's what's being said. Yeah.
But
there's none of this was really explored beyond what we've read. And as I say, there was the appellant could have but did not call any expert evidence of her own as to what, if anything, one could infer from this. So we're really left simply trying to extrapolate from the evidence for the pathologist a time of death in circumstances where what exploration there is a direct question. Are you able to say anything about time of death? No. So in my submission, it simply can't begin to support the suggestion that this conclusively demonstrates innocence of the appellant. Nor even, I say, the suggestion that this, more pertinently to the present inquiry, doesn't support the suggestion that this was a piece of circumstantial evidence that the jury were not entitled to rely upon. My Lord, I'll skip for now, if I may, over the blood evidence. Then we come to 47 in our printed case, the locked door, which was mentioned briefly by my learned friend, and the point, as I understand it, again, I've called it the patio door, but perhaps the kitchen door is more apt. It was locked from the inside, it appears, by the deceased. And as I understand the contention, it is said, well, that shows that it couldn't have been the appellant who was the attacker, or who had been the attacker, because it seems to be tolerably clear that the plunging of the knife from above into the space behind the clavicle was done on the patio. It seems to be said that what as I understand what's being said by the appellant is, well, that shows that it can't have been the appellant, because if the deceased had been fleeing the appellant, he would have known there was no point in locking the door, because one of the other doors couldn't lock, and therefore it shows you that this was actually somebody else. Well, it's a perfectly fair jury point, but not a very good one at that, in my respectful submission, because it attributes, as I put it in the case, a rather improbable train of thought to a man who's under lethal attack, that he would have reasoned it all through in that way, rather than simply whoever it was who had just come up and stabbed him from behind with a kitchen knife, rather than thinking that whoever it was who had done that needed to be got away from as quickly as possible and locking the door. So, in my respectful submission, that doesn't really go anywhere. So one is left at the end of the analysis, my Lord, with the need to look at the evidence as a whole. I accept that to some degree it is a matter of impression, but in my respectful submission, this was evidence taken as a whole, which a jury could properly have convicted, because the alternative hypotheses, however one goes through them, are all alternative hypotheses which the jury would have been and would be on a retrial entitled to discount. And they would therefore be entitled to come to the conclusion they were sure it was the appellant who was guilty of the offence. So, my Lord, for those reasons, I respectfully invite the board to advise that submission should be rejected, that is, that the board should rule, the submission that the board should rule there is no case to answer, and that should be rejected. And the question arises then what to do about it. There is the possibility, I suppose, that the board would say, well, we're going to reject that submission, but nevertheless leave it open to the Court of Appeal to take a view on the same question. But if your Lordship is with me, with the Crown, that actually there is a case to answer, then that perhaps is not a particularly sensible course of action, and we're then left with question of relief. And much emphasis has been placed by the appellant on the irregularity, or the supposed irregularity, of the board itself deciding that there should be a retrial, and I accept that the usual practice is that the question as to whether there is to be a retrial is one which is remitted to the local court. But, as I think has been observed in the course of Malone Friend's argument, that this is not quite the normal case. And I've touched on this already, so I won't belabor the point. I submit, if one looks at the judgment in the Court of Appeal, accepting, of course, the significant qualification that they didn't hear submissions from the appellant before they reached it, so everything they say has to be looked at with a degree of caution. But if one looks at what the Court of Appeal say on the central issue about whether there should be a retrial, they come down firmly in favour of the view that there should be a retrial. And the central issue is it in the public interest that there be a retrial? And it's not a very complicated or difficult question. And questions about whether a retrial is fairly possible because of things that have happened since, like publicity or whatever it might be that's alleged to have happened since, are I submit, precisely matters for the trial judge, who has all of the usual remedies available, ranging from saying this is a completely fanciful point to staying the proceedings altogether, and with lots of things in between, like ensuring that the jurors are people who are in a position to come to it with an open mind and making absolutely clear to them in directions that they do that. So that's all I submit a matter for the trial judge. But the overall question, is it in the public interest that this matter be retried if the appellant has a case to answer? In my submission, it virtually only admits of one answer. Plainly it is, but barring some special factor which the trial judge could deal with, as I've indicated. This is plainly a matter that could be dealt with, that should be dealt with in the public interest in the Bahamas. And that view has been essentially taken by the Court of Appeal already. And in my submission, one can see from the judgments in the Court of Appeal, that's what Justice of Appeal Isaacs thought. But he said so even though he recognised the difficulties in the what he perceived as the difficulties in the Crown's case. Can I just briefly take the board back to how the matter was dealt with? This is back in Volume 1, just to make this clear. And if it helps, I've set the references out in our case at page 1685 and following. But if we go to the judgment, first of all, of the President, she says at 113, para 49, simply that she agrees with, for the reasons indicated by Justice Isaacs in his judgment, I would remit the matter to the Supreme Court for retrial on the authority of Reed. So her ladyship has directed herself to read.
Sorry, the page again.
113, my lord.
113, thank you.
Para 49.
Yes.
So that's really all we can take from the judgment of the President. And as I mentioned earlier, one could, I suppose, say, well, when she says for the reasons indicated by Justice Appeal Isaacs, she's adopting everything, including his conclusion that there was a case to answer. But I've already accepted that the appellant was entitled to a clear answer from the President as to what she made of that aspect of the appeal. But then when we go on to see what Justice of Appeal Isaacs says on this question, having rejected the contention that there was no case to answer, he goes on to deal with the question of a retrial. Before I get to the retrial, I should say quite a lot of my own friend's submissions were directed to attacks either on the trial judge for the way he dealt with it in his rejection at trial of the no case submission that was made there, or of the Court of Appeal in the way in which Justice of Appeal Isaacs dealt with the no case submission that was made as part of the substantive appeal in the Court of Appeal. That, in my submission, doesn't really go anywhere, because in circumstances where we've accepted that the reasoning leading to the order for a retrial needs to be revisited because of the failure to address the no case submission, only Justice of Appeal Isaacs addressed it. Well, Justice of Appeal Isaacs addressed the no case submission and said there was a case to answer. Justice of Appeal Crane Scott said there wasn't a case to answer, and the President didn't say either way. That's the difficulty. So having accepted that, it doesn't really matter in my submission precisely why Justice of Appeal Isaacs dealt with the no case submission in the way that he did. What matters is on the question of the retrial, which I say which is plainly in contention unless my learned friend has persuaded you there was no case to answer. What matters is how that was dealt with by Justice of Appeal Isaacs, and we can pick that up at page 139, para 135, under the heading "Should there be a retrial?" There's a lengthy quotation from what Lord Diplock said in the leading authority of Reed and the Crown. There is reference at 136 to the Bahamas Court of Appeal having adopted those principles. 137, on a retrial, the Crown may very well take the opportunity to make good such deficiencies in its case that can be cured, and if a second chance, why not a third? That, of course, is echoing the way that Lord Diplock had put it in the Reed case. But, as I argue in our printed case, that must be taken to be Justice of Appeal Isaacs saying that in the context of his decision, his view, that there was a case to answer. And it only makes sense in that context. Then he goes on to talk about the public interest, and he here is essentially adopting the formulation that Lord Diplock used in the Reed case and applying it to the Bahamas. Nevertheless, the interest of the public in the Bahamas that those persons who are guilty of serious crime should be brought to justice and should not escape it merely because of some technical blunder by the judge, as in this case where the judge did not leave manslaughter as a possible verdict for the jury to consider. That was one of the reasons that Justice Isaacs' judgment should be quashed. Leads me to conclude that an order for a retrial would be in the interests of justice, and it would not, in my view, amount to an error of principle in the exercise of the power under Section 13 of the Court of Appeal Act. So that is a clear statement by Justice of Appeal Isaacs that the public interest in the Bahamas justifies a retrial, and that part of his reasoning is expressly adopted by the President when she says, for the reasons he gave, I accept that there should be a retrial. In fact, although Justice of Appeal Crane Scott, of course, dissents and says actually that the appeal should not only be allowed but should not be followed by a retrial, because her ladyship says that there was no case to answer, she nevertheless does deal with the Reed considerations. And my lord, we can pick that up at page 161 Para 221, where the learned Justice of Appeal sets out the power to order a new trial. There is again a lengthy quotation from Reed, in this case with certain matters being highlighted. The first of them on page 162, the power to order a retrial ought not to be exercised where, as in the instant case, a reason for setting aside the verdict is that the evidence adduced at the trial was insufficient to justify a conviction, which of course was Justice of Appeal Crane Scott's view of the case. Then various other factors are highlighted: the seriousness or otherwise of the offence, its prevalence, the expense and length of time for which a court and jury will be involved in fresh hearing, the consideration that any criminal trial is to some extent an ordeal for the defendant, the length of time that will have elapsed, the strength of the case presented by the prosecution at the previous trial. I'm only reading out, obviously, the underlined bits. The nature of crime, the particular circumstances in which it was committed, the current state of public opinion. And then finally, it is in the interests of the public, the complainant and the defendant himself, that the question of guilt or otherwise be determined finally by the verdict of a jury and is not left as something which must remain undecided by reason of a defect in the legal machinery. That's the guidance that is given. And there is then some discussion by Justice of Appeal Crane Scott about where that leads. And the conclusion is that Para 225, the circumstances of this case are not on all fours with those in Reed, falls between the two extremes, that's to say a case where the jury were bound to convict and where there was no case to answer. It's clearly not in the interest of justice to order a retrial because the prosecution evidence adduced at the trial was not sufficient to justify a conviction by a reasonable jury, even if properly directed. In short, this is a case where, like Reed, the prosecution should not be given another chance to cure evidential deficiencies in its case against the appellant. I am satisfied that despite the seriousness of these offences, the prevalence of murder in this jurisdiction and the interests of persons in this community in knowing that persons who are guilty of serious crimes are brought to justice and should not escape it, the evidence against the appellant is so weak and inconclusive that it is not in the interest of justice to order a new trial, and I decline to do so. What I respectfully submit we can infer from that is that had Justice of Appeal Crane Scott taken a different view about the no case question, had she thought, in other words, that there was a case to answer, it's tolerably clear that she would have been inclined to order a retrial, as did the majority.
Well,
now, I heavily qualify that, of course, by reference to the fact that my learned friend didn't get a chance to persuade the court to a different view. But what we don't see on this appeal to your Lordship's board is it being said, well, these are the specific things that we would have said had we been given the chance. These are the specific factors which mean that there should not be a retrial, where what is pressed on the board is simply, well, as a matter of principle, it's a matter for the Court of Appeal to consider, and the Court of Appeal should consider it, and therefore it should go to the Court of Appeal. Well, if that's all that's being pressed on the board, then in my respectful submission, in the circumstances of this case, the board is perfectly entitled to take the view that there is good reason to think the public interest in the Bahamas does favour a retrial, and provided that there is a case to answer, a retrial is what there should be, on the footing that any specific questions about the fairness of a retrial because of matters such as publicity, that's really the only matter which has been specifically addressed in the second supplementary record, are matters for the trial judge, dealt with by the trial judge. All that one's left with then is my own friend's submissions in general terms about the opportunity to strengthen the case, to make good deficiencies in the case. And one does, I submit, need to be quite clear about to what one is applying those words. It's settled by Reed that, save perhaps in exceptional circumstances, because courts hardly ever say never, one doesn't order a retrial where there was no case to answer. One doesn't allow the Crown a possibility of building a case where it didn't manage to do so at the trial. But if there is a case to answer, then in my submission, a retrial is as it were, the leading candidate for what one should do about it. Of course, one takes into account, nevertheless, the fact that the Crown might be entitled to bolster its case in some way, but it's difficult to see really how that factor has much to operate on. And it's counterbalanced in my submission by the fact that both parties actually have a chance to improve their case. And to take a specific example, because you were pressing my learned friend for an example on this subject, my learned friend referred to Miles Pritchard and the blue glass. And it was said, well, could the Crown perhaps call evidence to establish whether the DNA on the blue glass was or was not Miles Pritchard's? Well, yes, I suppose the Crown would be given that opportunity that, for whatever reason, it didn't take at the trial. But actually, so would the defendant be given that opportunity. It's not a question of asking, is the glass still available? Has it been tampered with? Can we get some DNA off it? We know what the DNA on the glass says. That's in the report. It's all set out in the annexes to the DNA report, listed by number. The point is, can you match that against? Can you match it against Miles Pritchard or not? That needs Miles Pritchard's DNA, not any more DNA off the glass. So it would be just as open to the appellant, if she wanted to do so, to call evidence on that subject, and on the subject of rigor mortis, etc., etc. So these considerations, I submit, really cut both ways, and they don't really go anywhere. And one is left essentially with the proposition that if there is a case to answer, then the public interest tends to suggest there should be a retrial, and in my submission, the board should say so, absent any good reason for thinking that there is some other factor which really only the Court of Appeal can consider. And in my submission, there isn't. Any other factors should be considered by the trial judge, but they will be about specific problems with a fair trial. And the trial judges are perfectly capable of dealing with that. So, somewhat, I think, ahead of schedule on both of our parts. I think, my Lord, subject to any further questions you might have, those are my submissions.
Well, there's just one question, Mr. Rowe. A common feature of the decisions of the board to remit for the decision of the Court of Appeal in the local jurisdiction, the question whether there should be a retrial has been that the local court is better placed to judge what the interests of justice require. In this case, we have two significant factors. First, that the Court of Appeal did not give the appellant, as it should have done, as you have conceded, the opportunity to make representations as to why there should not have been a retrial. And secondly, that the court was divided on the question of whether there should be a retrial, and we have the unfortunate circumstance that the President didn't advert to any reasons at all why she expressed agreement with Justice of Appeal Isaacs. I quite appreciate that your submission amounts to the proposition that one looks beyond those considerations, but are there not fairly potent factors that impel a reference back to the local court?
I certainly accept they are factors that support the proposition there should be a reference back to the local court. Absolutely, I can't imagine those factors away. I entirely accept that, and if that's the board's preference, then so be it. I merely make the point, however, that while ordinarily, certainly one would look to see what the local court said about it for good practical reasons and perhaps reasons of comity between the board and the local courts. In the circumstances of this case, you have the unusual situation that as I've sought to demonstrate, the local court, albeit, and I have to concede, of course, that this is a significant flaw in the whole thing, albeit they didn't invite submissions from the appellant first, but they came to the view that the public interest did require a retrial. And
yes, the setting for their decision on the public interest involves the omission of the court to allow the appellant to make submissions.
Yes, and that I quite accept. That very substantially weakens the force of the point that the Court of Appeal have already thought about it. But except that I would submit I'm entitled to point out that the appellant doesn't come here saying, well, if only you'd given me a chance to make submissions, I would have said
no,
X, Y, and Z.
But
that may be.
Is you, I think, have accepted that we would need to be satisfied that the Court of Appeal, having heard the submissions that have been made, would have still ordered a retrial.
Well, plainly, plainly it should have. Yes, should have. Plainly, if your lordships if your lordships were to come to the view that the Court of Appeal would have been bound to order a retrial if only they'd been addressed on it, then yes, we're in the same territory here as I think one of the cases that we cite in our printed case where there was a conviction was quashed, and without further ado, the Court of Appeal of the Bahamas by majority went on to say, we re-sentence you to 25 years imprisonment. And
Right.
the only exception, I think the board said in those circumstances, there might occasionally be cases where nothing could have been said to deviate the court from that course.
Right.
So plainly, I accept if we're in that territory, but I mean, it doesn't sound from your lordship's interventions as if we're likely to be in that territory. Then, if we're not in that territory, then it does become more a matter of discretionary judgment by the board. I don't think I would go so far as to accept that I only get an immediate order for a retrial if I persuade the board, that the Court of Appeal would have been bound to order a retrial. It's a question of discretion.
Should have.
Should have.
Yeah.
Should have. And there is another factor which is important in this context, which of course is the passage of time, because we are here now in 2020 talking about the possibility of a retrial of an offence committed in March 2015, and we are here at least in part. I take on board the comment that Lordship made earlier in my submissions before the short adjournment. We are here at least in part because of the appellant's wish to have this board rule that there shall be no retrial because there is no case to answer.
Well.
And that is the inevitable. If the board is in the territory of thinking, well, there is a case to answer, so the question is, do we order the retrial ourselves or do we remit them out of the Court of Appeal?
Yeah.
Then that is a factor to be considered. I don't think it's submitted by the appellant, even at its highest, that the board should say, we think there's a case to answer, but there shouldn't be a retrial. That would be to go too far. So those are the factors. And if the board comes down in favour of saying, no, this is a matter for the Court of Appeal, then I repeat my request that be accompanied by an indication which is as firm as can be in the circumstances where I appreciate this board is not in charge of civil procedure or this criminal procedure in the Bahamas, but as firm an indication as can be that decision should be made quickly by the Court of Appeal, so that there is no further prolongation of the agony for anybody.
The only other matter is your request that you be permitted to make a written submission in relation to the blood evidence. How soon can you do that?
How soon would your lordship like it?
Is 1 week enough?
Yes.
Thank you. Thank you very much indeed.
Thank you.
Now, Mr. Montgomery, you will, of course, have the opportunity to reply to any written submission.
1 week will be enough for us once we've...
Thank you very much indeed. We'll so order.
May I grapple with what has emerged possibly as one of the problems I have to address? The Judicial Committee has, on a number of occasions, and certainly Mr. Rowe on a large number of occasions, has referred to this as being the equivalent of a no case to answer submission at the close of the prosecution case. That in reality is not the circumstance which the board were considering in Reed as being the relevant question when retrials are the subject of discussion. The relevant question, so far as Reed is concerned, is whether the evidence was sufficient to justify conviction. In other words, it is a decision made looking back once all the evidence is in. So it is not subject to the usual concerns of a trial judge that he or she may usurp the functions of the jury, because at the close of the prosecution case, they're necessarily looking at inchoate evidence. There may be, indeed as there was in this case, there may be evidence caused by the defence, there may be material that adds further aspects to the evidential picture that may be of significance. And it's only really once you have all the evidence that you're in a position to assess whether or not there is a sufficient case to go to the jury. And certainly, so far as Lord Diplock is concerned in Reed, he speaks continually of whether the evidence is sufficient to justify conviction In other words, the test that would be applied by a Court of Appeal criminal division rather than the test that's applied by the judge at trial. And the difficulty with this case is that one doesn't get to the point of assessing, to use Lord Kerr's phrase, the particular strengths or weaknesses of various strands in a rope, as one would in a circumstantial case, if there remain hypotheses that cannot be surely discarded, which mean that the whole rope theory has been undermined. That is the whole point of what the board was saying in Varlac. Varlac is a case that deals fairly and squarely with the issue as to what a court of appeal, should do when considering whether or not there is sufficient evidence, if there is a hypothesis that cannot be disposed of with any certainty, that points to innocence. So you can forget about, you can have as many strands in the rope as you like. If the reality is you're looking at the wrong case because you have yet to dispose of the other hypotheses, then the Court of Appeal will say there is no sufficient evidence. And the case of Varlac is in the bundle. It's specifically referred to by the Court of Appeal in the Bahamas in the passage that we looked at. And in my respectful submission, that is the test which the board should use to guide its deliberations in this case, namely to determine whether it was possible, looking at now we know all the evidence, to reach a conclusion that one could confidently and surely exclude any competing hypotheses as to how Philip Vasyli met his death. So it is the exclusion of competing hypotheses that is required, not looking at it in the round in the way that Mr. Rowe tries to beguile you, but to look fairly and squarely at those pieces of evidence that give rise to the competing hypothesis and say, could a jury, properly directed, reasonably, and, because it's a criminal case, confidently reject that alternative hypothesis? And what is striking is that both Crane Scott and Judge of Appeal Isaacs say they cannot. Even Judge of Appeal Isaacs recognises in the part of his judgment that we looked at that there were unanswered competing hypotheses. That's his language. So,
just remind me where the passage in Varlac.
Yes, certainly. It's in Authorities Behind Volume 6. Authorities Behind Volume 5. Start again. Authorities Behind Flag 6, page 1774. And it's citing from Chief Justice King in Question of Law Reserved. So it's the three passages in that indented portion of the judgment. The first paragraph, the Court of Appeal Criminal Division is looking at whether a reasonable mind could reach a conclusion of guilty beyond reasonable doubt and therefore exclude any competing hypothesis. And he makes the emphasis that this is whether it's capable, 5 lines up from the bottom, capable of causing a reasonable mind to exclude any competing hypotheses as unreasonable. And then over the page, in a circumstantial case, the prosecution evidence must be accepted on inferences most favourable to the prosecution. A reasonable mind could not reach a conclusion of guilt beyond reasonable doubt or could not exclude all hypotheses consistent with innocence as not reasonably open on the evidence. So that is why it is simply not good enough to step back and look at this.
But he's not saying that that's different from the function of no case to answer in the High Court.
No, the Reed formulation is the one that I would draw attention to, which effectively says behind authorities behind 10 that what the court is concerned with in considering the interests of justice is the sufficiency of the evidence. So you can see at the bottom of 1811, for example, he describes it: the evidence adduced at trial was insufficient to justify a conviction by a reasonable jury, even if properly directed.
But at 1810E, he's talking about evidence adduced by the prosecution.
He's talking about evidence was insufficient to justify conviction.
The evidence
Yes.
adduced by the prosecution.
Yes. But it is an important point that he's not talking about a submission of no case. He's talking about, as all courts of appeal are required to do, looking at the evidential position at the close of the case and assessing the verdict of the jury that's been returned. Which is why there's no self-denying ordinance. The Court of Appeal Criminal Division doesn't step back and say, I mustn't interfere with the role of the jury. Court of Appeal Criminal Division is looking at a case where a jury is convicted, and it's required to say, was there sufficient here? Does it pass the Varlac test that we're satisfied the jury were able to exclude the hypothesis that he died on the 24th, or they were able to exclude the hypothesis that there was the blue glass man there.
So that means, does it, that the Court of Appeal, in deciding whether to order a retrial, as opposed to deciding whether to quash a conviction, has to be satisfied that all tenable hypotheses advanced by the appellant have been extinguished.
Can be surely extinguished, yes. And that
I don't see any unequivocal statement to that effect in either Varlac or Reed. I mean, is there a particular passage where you say that emerges? Because that seems to me to be...
well, it's the test that's being applied both in Au and in Reed, I would submit. If you look at it in Au, you've got the same issue being that arises. They are considering whether or not, so far as in exercising the power to order a retrial, because what you have is an open-textured discretion to do what is required in the interest of justice. That's the terms in which this particular Court of Appeal Act is set, namely that making a positive decision that the interests of justice require an order for a retrial. That's your task. That's 13.2 of the Court of Appeal Act. And that's why they say it is necessary for the board to consider the state of the evidence at the point when they are deciding whether or not to order a retrial. So, and that's exactly what, so if you look at Au, as I say, it's the paired case with Reed. That is why, if we take Au at its behind flag 4, begins at 1732 and the passage is at 1739, internal page 358. Lord Diplock points out at D, the strength of the evidence adduced against the defendant in the previous trial is clearly one of the factors to be taken into consideration. At the one extreme, it may be so tenuous that a verdict of guilty upon that evidence would be set aside as unsafe or unsatisfactory. In such a case, the Court of Appeal would be exercising its discretion unjudicially if it ordered a new trial. So you are
again talking about the prosecution evidence.
no, my lord. He's talking about the evidence. Obviously, mainly it will come from the prosecution, but they're looking at the position where there's a conviction.
Well, the prefatory words of the paragraph are the strength of the evidence adduced against the defendant. That must be the evidence adduced by the prosecution, surely.
Well, your lordship's been more fortunate in your defendants than I have, because I've certainly had cases where the evidence adduced by the defendant has been sufficient to sink them.
I didn't have the opportunity that you've had, enjoyed, Ms. Montgomery, of appearing in criminal trials to any significant extent. But
in any event, what you are looking, you are a criminal court of appeal. You're looking at a verdict and you're looking back at evidence. And in order to satisfy that, and you've got to be positively satisfied it is in the interests of justice to order a retrial, you are required to assess whether or not the evidence was safe and satisfactory. That is your duty. And in my submission, that is what is meant both in Au and in Reed, where Lord Diplock refers to the need for the court to consider whether or not the evidence was sufficient to warrant conviction.
right, well, we have the point, I think.
Yes. But it makes an important difference, because there is no room for judicial deference.
So I can see that it makes a very important difference. It's just a question of whether, on proper analysis, this is what Lord Diplock has been saying. But in any event, you've made the submission. It's up to us.
I have. I also do need to say something about remission, again, with the benefit of having the Judicial Committee consider Reed. It is simply wrong for Mr. Rowe to say, if there's a case to answer, Reed suggests that the interests of justice will be answered simply by ordering a retrial. That is the polar opposite of what Reed says. Reed says, if there is a case to answer, then you are required to give careful scrutiny to the variety of factors, catalogue of factors, I think is Lord Diplock's word used more accurately, that will arise in considering what the interests of justice may require. To suggest that once there is a case to answer, there is but one question, namely, is it in the public interest for there to be a retrial, is completely wrong. Reed is saying the exact opposite. As for the suggestion that I have not addressed you on what might have been said to the Court of Appeal, I have made it clear that there would be submissions in relation to each of the factors that Lord Reed there refers to as being featuring in the catalogue of factors. And I've given you the concrete example of a requirement to consider the prejudicial publicity that has gone before, and in addition, the need to consider what, if anything, might be adduced by way of additional expert evidence. And that is always going to be something that is relevant. And indeed, if one looks in the bundle of authorities, it's quite clear that, for example, if the prosecution are going to call additional expert evidence about the DNA, that is a factor that would be relevant to any decision as to whether or not to order a retrial. Nichols, which is in the bundle behind flag 9, is a classic example of that. Nichols is a case where there was some evidence, but as the court said at 1803, so it's flag 9, 1803, that was a case in which there was an invitation to remit the matter to the Court of Appeal, and the board referred with concern at the bottom 3 lines of page 1803 to the fact that the prosecution had failed to adduce expert evidence on the significance of the bullet wounds, which formed part of the reasoning of their lordships, justifying quashing the conviction, it would be wrong to permit the prosecution, through Dr. Bascom-Adams, to make good this deficiency. And a new prosecution without such evidence would in all probability fail at trial. So it is at least, we would submit, a legitimate consideration, even in a weak case, which may pass the test, is it unsafe or unsatisfactory? It is relevant, even in a weak case, for the court considering whether there should be a retrial to look at whether what is proposed is that the prosecution should be given an opportunity to call expert evidence they chose not to.
Except that that was one which would in all probability fail.
Yes.
Without the extra evidence.
Yes, but one is talking about, it's not at the extreme end, which would fail, it's would in all probability fail. So it's talking about weak cases rather than fundamentally flawed cases. There's a spectrum, obviously. In my submission, they're making it clear, and they make it clear in Reed that the strength of the case is a relevant consideration, even if it is sufficient to get past the analysis, is it unsafe and unsatisfactory?
Yes.
So far as the evidence is concerned, clearly the board is going to consider the evidence in relation to blood that's going to come later. But if I may just say something about the evidence in relation to Blue Glass Man, because their submissions are complete there. The reality is that Mr. Rowe has demonstrated that this is a murder that's unlikely to have been committed by an intruder. He has simply not dealt with the possibility that this was a visitor. No amount of evidence about the state of the gatehouse at this gated community deals with that issue, because as I hope is plain, and as the evidence made clear, this is a community that's something like 1.5 miles long and 0.5 mile deep. It is a massive area. There's one gatehouse. It's not a gate adjacent to the house. It is 0.5 mile away. And there are large numbers of residences. And in our respectful submission, it does not help him dispose of the hypothesis that this was a visitor who drank from the blue glass to say, oh, well, it wasn't an intruder. The reality is that the evidence that there was a third person at the house that night was accepted by the police officer, Mr. Stubbs, and although it is said, well, there's no evidence even that the glass was being used or drunk from, it was on the table. The likelihood of it having got there without being taken by somebody and used by somebody whose DNA cannot be identified is, in our submission, fanciful. Clearly it had been used, and clearly the swab taken from the rim was intended to reveal what the DNA of the person using it was. So the blue glass man point is a very simple one. The prosecution hypothesis was it's only Mrs. Vasyli who was there, and only she who could have stabbed him. And the blue glass man, in our respectful submission, demonstrates that there is a competing hypothesis that there was a visitor drinking from the blue glass who in the end, for whatever reason, struck the fatal blow.
Yes.
On any view, the fatal blow is struck from outside, and that's why it's relevant that the door is locked. If it was Mrs. Vasyli, it would not make sense to lock the door. So far as the timings are concerned, I indicated that I would raise the point that the certificate went in by way of admission, and that the position as a matter of Bahamian law is, as I suspected, it mirrors that of the law, at least in England and Wales. And I've got section 19 of the Evidence Act to hand up. Can I just take one? So it's exactly the same as it would be under the Criminal Evidence Act in England and Wales.
Yes.
And as you can see, section 19 provides for proof by way of formal admissions. And you can see evidence may be admitted for the purpose of proceedings by or on behalf of the prosecutor or the accused person, and the admission by any party of any fact under this section, 19.1. Subject to the provisions of this section, any fact of which oral evidence may be given in any criminal proceedings may be admitted for the purpose of these proceedings by or on behalf of the prosecutor or the accused person, and the admission by any person, any party of any such fact under this section shall, as against that party, be conclusive evidence in those proceedings of the fact admitted. So it's one of those...
You have to go on to subsection 2b as to how the admission may be made. I mean, it's an admission that's being made.
Yes, it's an admission in court.
It is not the fact that you've put something in that's got that's a document that has got a particular fact in it. Isn't this more formal than that?
It says formal admission.
Yeah.
No, because there's no other route by which it can get in. So it gets in, as they call it, by stipulation. That's the word they use. But stipulation, in my respectful submission, can only be a synonym for admission. The only other route is for the evidence to be called.
Yes, but it's admission in evidence.
Admission in court in evidence, yes.
Yes, but the question is, what is its significance once admitted? Does it establish, beyond the capacity for contradiction, every single item that the document contains?
Yes, it does. And
that would elevate it to a status well beyond that of oral evidence.
Yes, and that's the position in England and Wales.
That's not what this says, surely. This is a formal admission of a particular fact. I admit that he was killed. I admit that he did something. You can't treat the certificate as a formal admission that he was killed at a certain time when you've got evidence from the pathologist who says, like, you can't place the time of death.
You've got to look and say, what is being admitted? What is being admitted is the statement of Carla Major and the certificate of death. And so far as that is concerned, it would be common in England and Wales, and indeed the bench book shows it, and any of the board who sat on criminal trials will have given this direction, that you say to the jury that the statement was read by agreement or by admission, and you must take those facts as being true.
It's not my field, but I'm extraordinarily surprised that was the position.
Well, does it follow that the court is bound to accept the truth of the statements, all the statements contained in the death certificate?
Well, my lord, insofar as it's uncontested and led by the prosecution, yes, apart from anything else, that is the assertion being made at the prosecution's choice. They choose to put it in that is being laid before the court.
There was also evidence from the pathologist herself that she could not say
about the time.
The time of the death.
She didn't say there was any difficulty about the date.
Well, the date would depend on the time of death. Whether it was the 24th or the 23rd would depend on whether she was able to place with any precision the time of death.
Well, my lord, the two aren't necessarily capable of being dealt with in the same way. If she's right about the rigour still being present at 13:15, then you can say death's taken place on the 24th if one takes, even as an average, 12 hours.
Yes,
I understand that point, but the question then, the question here is whether the prosecution should be taken as accepting that the death in fact occurred on the 24th.
But they put the evidence in. That's
It's not a statement of fact that the death occurred then. At most, it's a statement of the writer's belief at the time she wrote the report. That's what it was.
My lord, yes, but a statement of belief adduced by the prosecution. So what they are in effect asking you to do is say, we put in front of the jury the fact that her belief was he died on the 24th, and we are now saying that a reasonable jury, properly directed, could be certain that that was wrong, could be certain that that is evidence that is simply to be disregarded.
I mean, that's a different point, and that's a point you can reasonably make. Here we're talking about a formal admission which becomes conclusive evidence of the fact.
I'm not going to press it any further because obviously it's not been developed in this case, but the reality is that under the law of the Bahamas, you only get to put in evidence by calling a witness or by, they've got some business record rules, or by this process of admitting facts. And that is what is going on in our submission when the evidence of Carla Major is read.
I was just going to ask you whether, in fact, this statute has provisions in relation to hearsay, documentary hearsay.
It does. It's certainly got something on business records. I don't think it's got anything that looks like our 2003 Act. So I think it's got the old, it looks like it's been taken from the old 1968 Criminal Evidence Act. And it looks like it hasn't been updated since then.
If it helps, section 39 2E talks about statements contained in official records kept for the information of the Crown or for public reference.
Yeah.
That would seem to cover the death certificate.
Sorry, what does it say about that?
So it's section 39 2E, forgive me. Hearsay evidence may be admitted, E, where the statement is contained in any official record, book or register kept for the information of the Crown or for public reference and was made as a result of an inquiry by a public servant in discharge of a duty enjoined by the law of the country in which such official record, book or register is kept. That might.
That's just simply admission of the document.
Yes.
As evidence, but doesn't make it conclusive.
No.
Right.
And of course, as we know, it didn't go in as a hearsay document. It went in as part of the Carla Major exhibit. So it really comes to no more than this, so far as the prosecution are concerned. They say, both through Mr. Rowe and to the Court of Appeal, we accept there are the other possibilities. There's the possibility of a visitor. There's the possibility of death occurring at a time when the appellant is not there. What they don't say to you is how you can be sure those possibilities can be safely disposed of. That is the problem. No amount of disagreements between a married couple or the tapestry that involves roaming around the beach points and talking about what happened when the Pritchards were there helps one say this is certainly a case where only Mrs. Vasyli can be the assailant. And it certainly doesn't help them, where, as I say, the points that I make about timing, about rigour, about the blue glass man, is based upon their evidence, not upon the defence evidence. So the prosecution would be in the invidious position, as indeed I understand Mr. Rowe to recognise, to be saying, oh, well, he can ignore parts of our case because we say they are not relevant to the case that you have to decide. I do need, though, to say one thing about his approach to timing, and that is to suggest that the prosecution would be entitled to invite the jury to regard the evidence of Mitchell Matthew about when he saw the appellant at the Lily Pond house as being in some way colourable or doubtful. It was specifically accepted, and I should give the board this reference, it was specifically accepted by the prosecutor in the Court of Appeal that so far as he was concerned there was no evidence to support a submission that Mrs. Vasyli had returned to the Lily Pond house at any time after 9:10, and that is in submissions made by Mr. Garvin for the Crown at, get the right reference, 11:59. Sorry, I said volume 6 and I think it's volume 5. Yes, volume 5, 11:59.
Where's the evidence about how long it took to walk between the two?
It's from Mrs. Vasyli's interview. So that is volume 4. At 847.
Thank you.
And this is the prosecutor in the Court of Appeal, 11:59. There's evidence of Mitchell Matthew that the appellant's the resident of the daughter at 10 o'clock. In fact, it's 9:10. And Mr. Gaskin says, yes, I think he said 9:30 or something. As I say, 9:10. There's no evidence that she left that residence on the Crown's case until the next morning when she was informed that her husband was dead. Answer, yes, my lords.
Well, I think you made the submission to us that Mr. Gaskin had accepted that
There was no
there was no evidence that she arrived after 9:10.
Yeah, well, they accepted Mitchell Matthew. Mitchell Matthew was read to the jury without objection.
He said about.
Yes.
The exact terms in which he spoke are set out in the defence speech, because the judge obviously only sums up part of them, and so your lordships can have the full extent of what he said. The statement is read out as part of the defence speech in beginning at page 744 and going on to, it ends at 748. And he's asked, when I left, the question is, I went upstairs to pack my bag and Donna was there.
Reading from 747?
747, my lord.
Thank you.
Line 9, it begins, question 20. Do you recall what time that was? It was roughly around 9 p.m. or 10 past 9. Yes, and Mr. Rowe asked me to read this. 746. When I left Lauren and Quintin, I went upstairs to pack my bags, and Donna was there. Do you recall what time that was? It was roughly around 9 or 10 p.m. But on any view, there on the 23rd and there before, the 12-hour rigor period would run. 12-hour rigor period would run only till about 1 o'clock in the morning of the 24th.
What time do you say that the rigor period would run?
So,
What time would the death have occurred on your workings out for the rigor?
so 1:15 in the morning, 01:15. So counting back 12 from 13:15.
So you've interpreted it as 12 hours from the time
Yes,
of the death?
and that's how the judge interpreted it, that's how the prosecution understood it, that's the basis on which they make the submission. I accept that.
Well, that's tantamount to saying that 12 hours is the maximum. Whereas that
because of
wasn't the evidence of the pathologist, was it?
Because of the point, no, I accept that. So that the pathologist is clearly saying average.
Yes.
But there is the point that if it's beyond whatever the point is of peak, then once you break it, then the limb will fall down. And that's the point about it, as was clear from the evidence, being accepted by the pathologist as still having rigour present at 13:15 when he's been...
But the reason I was asking you about the 12 hours
Yes.
is because there is that passage where it is said 12 hours from...
From 4, yes. But on the basis that I accept linguistically it's capable of being understood in that way, it appears, certainly from the judge's summing up and certainly from the Court of Appeal, that the view was taken that what was meant by that was 12 hours from the point of death. And that, in my submission, clearly is what is summed up by the judge when he deals with this. So he says in terms that the evidence about rigour is page 44.
Thank you.
So he gives it as counting from 1:15. What she said, that Sands said, if you break rigour within the period of between 2 and 4 and 12 hours, that is, someone is in rigour, then it will go back to its original position. If you break rigour after 12 hours, then it won't reset. So whilst I've also recognised that that is not as clearly expressed as it might be, that is what both parties understood the effect of the evidence was. And indeed confirmed that in the Court of Appeal, because I showed you Judge of Appeal Isaac's summary of it at paragraph 105.
I hesitate to interrupt my learned friend, but I'm confused now because my learned friend's printed case says explicitly 14 to 16 hours previously.
Yes.
Page 1677.
Well, all of this will require a good deal of examination and analysis. I don't think we ought to rush to any firm conclusion at this stage. Yes.
So the position so far as the doctor's evidence is concerned is it's capable of being read both ways. But either way, even if it's 16 hours, then one has the position that even that will only take you back to 9:15 as an outside time. And I ought to make this point before I sit down. Mr. Rowe occasionally said, well, the defence haven't called any evidence, they haven't proved that this could have been committed by an invitee, they haven't proved that she was there at the lily pond the whole time. It is, and I'm sure that the committee will remember this, for them to disprove that.
Oh, fine. Well, I think in fairness to him, he did say that you weren't under any obligation to reduce the evidence. He
did, but the impression may have been given that in some way, because of the paucity of evidence on these topics, on these competing hypotheses, one could dismiss them. But the reality is one's not saying, are these hypotheses fully established on the evidence? One is required to say, are these hypotheses capable of being confidently rejected? And that's the point that I make. And that is what both Mr. Judge of Appeal Isaacs and Crane Scott, I haven't spent a lot of time on her judgment, but both of them recognise that the competing hypotheses were not satisfactorily disposed of. So I think that is all I need to say to you. Can I just check?
Yes, of course.
Can I assist any member of the committee?
Thank you very much. I don't think so. Thank you. Very grateful to for the assistance that you and Mr. Rowe have given. And of course, ably assisted, no doubt, as they were, by those who didn't get the opportunity to speak. The board will take time to consider what advice they will humbly tender to Her Majesty, and the court is now adjourned.